If you own Iowa real estate and you're thinking about moving it into a trust or an LLC, what used to be a simple deed change now has a second layer you cannot ignore. On March 1st, 2026, a new federal rule from FinCEN took effect. It adds a federal reporting requirement on top of the usual Iowa paperwork for most of these transfers. If you follow the old playbook and just record a deed, you might be missing a federal step. In this video, I'm going to show you when this new rule actually applies, what has to happen now when you move property into an entity or trust, and how to get it done cleanly without turning yourself into a part-time compliance officer. I'm Jeremy Danilson, an Iowa real estate attorney. My firm helps Iowa owners and investors buy, sell, and transfer property every single day. Let's get into it. This video is for you if you already own an Iowa property in your personal name, you want to move it into an LLC or a trust for liability, estate planning, or investment reasons, and you've heard something about a new FinCEN rule and you're not sure what it changes. My goal is not to turn you into a FinCEN expert. My goal is to give you a clear map of what has to happen on both the Iowa side and the federal side so you don't accidentally skip a required filing and know what to look for when you hire someone to handle it. About halfway through, I'll show you how we bundle this into a single flat fee service at our firm. If you already know you want help, there's a link below where you can book a short call and we'll look at your specific property. What actually changed? Well, let's start with what hasn't changed. If you own a property in Iowa and you want it in an LLC or trust, you do use a quitclaim deed. You deed the property from yourself as an individual to your entity or trust. That deed gets signed, notarized, and recorded with the county recorder. That's the Iowa side of the transfer. And that part is very familiar. What changed on March 1st is that for a lot of these transfers, there's now a second step, a federal real estate report that has to be filed with FinCEN. Here's the simplest way to think about it. The new rule focuses on non-finance transfers of residential real estate where the new owner is a legal entity or a trust. So, if you are moving a rental or other residential property you already own into an LLC, a corporation, or a trust, there's a good chance this new rule applies and a FinCEN report is required. So instead of just record a deed, the job for many of these transfers is now get the deed right on the Iowa side and file the FinCEN report correctly and on time on the federal side. Both pieces matter. Miss either one, and the job isn't actually done. To keep this simple, I'm going to break the whole process down into 3 parts. Decide whether your transfer is actually covered, gather the information FinCEN cares about, and execute the transfer correctly, deed and report. We'll go through each one, and I'll show you what we do for clients at each step. Part 1. Is your transfer covered by this rule? Not every transfer is reportable, but many of the scenarios investors care about are. You want to look at 3 questions. Is the property residential real estate under the rule? Think single-family homes, small multifamily, condos, and some residential adjacent properties. Is this a non-financed transfer? In other words, we're not talking about a traditional bank-financed purchase with a mortgage. We're talking about all-cash deals and internal transfers like quitclaiming into your LLC or possibly your trust. Is the new owner a legal entity or a trust? That includes LLCs, corporations, and most trusts that investors use. If you check those boxes, the new FinCEN rule is on the table and a real estate report is often required. In our office, we answer these questions with you on the front end. During our intake, we confirm the property type, confirm whether there's any institutional financing involved, and confirm exactly what entity or trust is receiving the property. If it's not a covered transfer, we'll tell you that. And if it is, we treat it as a 2-piece job from day one. Part 2, gather the beneficial ownership information. Once you know your transfer is covered, the heart of the FinCEN report is beneficial ownership of the entity or trust that's getting the property. Here's what that means in plain English. FinCEN wants to know who ultimately owns or controls the LLC or trust that's receiving the real estate. For each of these people, the report requires full legal name, date of birth, current address, a government-issued ID number, like a driver's license or a passport, plus the issuing jurisdiction. 2 common investor scenarios: single-member LLC, might just be you, or a multi-member LLC or certain trusts. There may be 2, 3, or more beneficial owners that all have to be listed. Where do people get tripped up? They don't know how their entity is actually structured. They forget about a spouse, partner, or other member who meets the definition of a beneficial owner. They don't collect the ID details before they start, so the process stalls. At Danilson Law, we handle this by clarifying the structure of your LLC or trust with you, identifying everyone who qualifies as a beneficial owner under the rule, and giving you a simple checklist so those people can securely provide the exact information we need for the report. You don't have to interpret the rule text yourself. We walk you through who has to be on the list and what details we need from them. Part 3, execute the transfer correctly. Iowa deed and FinCEN report. Once we know the transfer is reportable and we have the owners identified, there are 2 things that have to be done right: the quitclaim deed on the Iowa side and the FinCEN real estate report on the federal side. On the deed side, our office pulls the current legal description from the last recorded deed or county records, prepares the new quitclaim deed from you individually to your LLC or trust, makes sure names and legal descriptions match exactly, coordinates signatures and notarization, and record the deed with the correct county recorder. On the FinCEN side, we prepare the real estate report in FinCEN's electronic system, populate it with the property details, transaction information, entity or trust information, and the beneficial owners you identified. File it within the required deadline after the transfer, and keep a record that it was filed. From your perspective, this is one engagement. Behind the scenes, we're doing both the Iowa paperwork and the FinCEN filing, so nothing falls through the cracks. Let me pause here and talk about the biggest mistakes I see around this rule, because if any of these sound like you, it's a good sign you shouldn't be trying to wing this. Mistake 1, transferring property with no idea the FinCEN rule even exists. This rule is brand new as I'm recording this. Most owners and even many professionals are just starting to hear about it. But if your transfer is covered and no report gets filed, you're out of compliance with federal law, even if your local county deed looks fine. Mistake 2, drafting and recording your own deed without realizing you just put the federal filing on your own shoulders. A lot of investors are used to grabbing a quitclaim deed form, filling it out themselves, and dropping it off at the county recorder. Under the new rule, that can make you the reporting person on a covered FinCEN transaction because you're the one who prepared the deed. From your point of view, you just filed a simple deed. From FinCEN's point of view, there's now a transfer into an entity or a trust in a real estate report they expect to see tied to your name. If that report never gets filed because you didn't even know it existed, you've got a federal compliance problem with your name on it, not just a piece of paper in the county records. Mistake 3, assuming your usual closing company just handles it. Not every closing professional has built a workflow for these reports yet. Some are focused only on finance transactions. If you're doing internal transfers or all cash entity purchases, you want to know who is actually preparing and filing the real estate report, not just assume someone is. Mistake 4, trying to reverse engineer the rule yourself from articles and forms. You could do that, but you'll spend hours reading a brand new federal rule and you still won't be as comfortable as someone who's doing these filings every week. If you already know you don't want to be the test case for this new rule, there's a link in the description. You can book a short call with our office and we'll look at your specific property and tell you exactly which pieces apply. Now let me walk you through how we bundle this for clients so it's simple. How we handle this at Danilson Law. When someone comes to us to move Iowa property into a trust or LLC, we treat it as one job with 2 parts. We confirm whether your transfer is reportable under the FinCEN rule. Prepare and record the quitclaim deed, collect and organize beneficial ownership information, and prepare and file the FinCEN real estate report on your behalf. If you're buying a property and putting it directly into an LLC or trust at closing, that FinCEN reporting piece lives inside our premium assured cash buyer closing tier. It's included in the flat fee for that tier. The deed, title work, secure closing lock closing, and the federal report are all handled together. If you already own the property and you just want to move it into an entity or trust, you don't need a full closing. You need a properly drafted and recorded quitclaim deed and a FinCEN real estate report when the rule says it's required. We package that as a standalone service at a flat fee. One engagement covers both the deed and the FinCEN filing for that transfer. If you own multiple properties you want to move into entities, we look at your whole portfolio, determine which transfers will require their own report, and map out a plan so you know exactly what's going to happen, when, and for how much. The idea is simple. You stay focused on the investment and planning decisions, and we handle the mechanics of making the paperwork line up with this new law. Section 4, timing and next steps. 2 quick timing points before we wrap up. First, don't wait until after you've signed and recorded a deed to think about FinCEN. The reporting deadlines run from the time of the transfer. It's much cleaner to bake the federal piece into the plan on the front end than to play catch up after the fact. Second, if you have a CPA, financial advisor, or estate planner involved, loop them in early. We work with those professionals all the time. Their advice on structure and tax planning, combined with our role on the deed and FinCEN side, makes sure the legal paperwork supports the plan you've put together. If you own Iowa real estate and you're planning to move it into an LLC or trust, the process is still very doable. It just has a new federal layer now that has to be handled correctly. If you want help with that, you can call our office or visit danilsonlaw.com to book a call. We'll look at your specific property or portfolio, tell you whether the FinCEN rule applies, and quote you a flat fee to handle the deed and, when required, the FinCEN filing together. If this video was helpful, subscribe to the channel. We're going to keep covering the FinCEN rule and how they affect Iowa owners and investors as this develops. I'm Jeremy Danilson with Danilson Law. Thanks for watching, and I'll see you on the next one.